Hi guys, this video is a continuation of chapter 1 of IPC and this is part 3. Let's begin with the topic of jurisdiction. Meaning of jurisdiction. It means power of a court to adjudicate cases and issue orders, or territory within which a court or government agency may properly exercise its power. One of the most fundamental questions of law is whether a given court has jurisdiction to preside over a given case. A jurisdictional question may be broken down into three components: whether there is jurisdiction over person, whether there is jurisdiction over the subject matter, or whether there is jurisdiction to render the particular judgment sought. The term jurisdiction is really synonymous with the word power. Any court possesses jurisdiction over matters only to the extent granted to it by constitution or legislation of the sovereignty on behalf of which it functions. There are two types of judicial jurisdiction: intra-territorial jurisdiction and extraterritorial jurisdiction. Intra-territorial jurisdiction of IPC. Here are some of the important factors of intra-territorial jurisdiction. A. Section 2. It explains about intra-territorial jurisdiction of Indian criminal codes. Every person shall be punished who commits an offence within India. The words every person clearly say that, subject to general exceptions, every person irrespective of caste, religion, region, etc. shall be punished if he is proved guilty under the provisions of this code. B. Foreigner. A foreigner who is guilty of an offence under this code shall be punishable under this code if he has committed any offence in India, although the alleged offence might have not been an offence in his own country. A. Who is a citizen of Uganda commits theft in India. Let's assume that the theft is not an offence in Uganda, but still A will be prosecuted under IPC under section 378 as the offence was committed on Indian territory. C. Persons exempted from IPC. Section 2 mentions every person within India. However, there are certain persons exempted from jurisdiction of criminal courts. These persons are given certain rights, privileges, etc. This is the same position in other countries also. Such persons are: A. Foreign sovereigns. Foreign sovereigns are the persons completely exempted from jurisdiction of Indian criminal courts. Foreign sovereign means a sovereign state. Sovereignty means the independent authority of a state. It has two aspects, internal and external. From the internal standpoint, it means that it has power to legislate on any subject. The external sovereignty of a state means that it is not subject to control of any other state or external power. That includes immunity from Indian courts. B. Ambassadors. Certain immunities and privileges have been granted to ambassadors of other countries by United Nations organization. Accordingly, every country has passed separate acts giving immunities and privileges to ambassadors. C. Alien. The military persons of alien enemies do not come under jurisdiction of ordinary criminal courts for the acts done connecting with the war. However, if they commit theft, robbery, rape, etc. unconnected with war, they shall be tried by the Indian criminal courts. D. Warships. The warships entered into the Indian Sea waters cannot be tried under the ordinary criminal courts. The public international law applies to such men of war. E. President and governors. The President of India and the governors of the various states are exempted from jurisdiction of criminal courts by Article 361 of Indian Constitution. Foreign Army. The foreign army personnel entered into the Indian territories with the permission of Indian government is exempted from jurisdiction of criminal courts. D. Within India. This phrase in section 2 denotes that whoever commits any offence within India shall be punishable. It shows the intra-territorial jurisdiction. According to Gazette of India Extraordinary Part-3, section 2 dated 30/9/1967, the territorial waters of India extend to territorial sea waters up to a distance of 12 nautical miles measured from appropriate baseline. E. High seas. High seas are open to all and represent the entire sea space beyond the 3 miles limit of the shore. This expression includes all ocean seas, bays, channels, rivers, creeks, and waters below the low water mark, and where great ships could go, with the exception only of such parts of such ocean as were within the territory of some country. In other matters than crimes connected with admiralty jurisdiction, it may be important at times to discriminate between the sea and the high sea. But in crimes, the seas or the high seas or the ocean means much the same. Territory of state comprise its ports and harbors, the mouths of its rivers, its landlocked bays. By the usage of nations, the territorial jurisdiction extend also to marine leagues seawards. This belt of sea is known as territorial waters. Oceans, seas and waters outside national jurisdiction are also referred as high seas, or in Latin mare liberum, meaning free sea. The Convention on High Seas, which has 63 signatories, defined high seas to mean all the parts of sea that are not included in the territorial sea or in the internal waters of the state, and where no state may validly purport to subject any part of them to its sovereignty. The Convention on High Seas was replaced by United Nations Convention on the Law of Sea, which recognized exclusive economic zones extending 200 nautical miles from the baseline, where coastal states have sovereign rights to the water column and sea harbor as well as natural resources found there. Ships sailing in the high seas are generally under the jurisdiction of the flag state, if there is one. However, when a ship is involved in certain criminal acts, such as piracy, any nation can exercise jurisdiction under the doctrine of universal jurisdiction. International waters can be contrasted with internal waters, territorial waters, and exclusive economic zones.